Boa noite a todos. É um prazer muito grande estar tomando parte, né, e conseguindo ver concretizado esse nosso terceiro CVPID, que é uma realização que nos é muito cara, né, professora Kelly, professor André, professor Milton, e coube a mim, então, o privilégio de apresentar o professor Reto Hilty. O professor Reto estudou engenharia mecânica antes de estudar direito na Universidade de Zurique, né? Zurique, na Suíça. Ele é suíço. Tá? Existe uma luta deixar isso usada, né? Ele realizou o seu trabalho de formação para se tornar um professor universitário em Direito Civil na Universidade de Berna. E desde então ele é professor titular da área de Tecnologia e Direito da Informação em Zurique. É também diretor emérito do Instituto Max Planck para Inovação e Concorrência na cidade de Munique, na Alemanha, e professor tanto das universidades de Zurique como de Munique, respectivamente na Suíça e na Alemanha. Eu vou bem pequenininho, assim, curtinho, saudá-lo também em alemão e inglês, porque há toda evidência que não fala português, tá? Então, só por uma questão de cortesia, perdoe-me. Lieber Professor Hilty, ich freue mich so sehr, dass wir heute hier sind, um über geistiges Eigentum zu sprechen. Sie sind herzlich willkommen hier bei uns in Porto Alegre, in Brasilien. Es ist eine große Ehre für uns, lernen von Ihnen zu dürfen. So, dear Professor Hilty, it's a great honor, thank you, honor to be here today, having you talking with us about intellectual property rights and sharing your knowledge with us. So, without further delays, I would like to introduce you Professor Reto Hilty.
Thank you so much, dear Lisiane, dear Milton. First of all, of course, for this invitation to Porto Alegre, which is very interesting. I had the chance to visit it today, and also for the very kind introduction. It's a great honor and a particular pleasure for me to be here to give a speech at the beginning of this third Brazilian Congress on Intellectual Property and Law. Ladies and gentlemen, dear colleagues, I don't know whether you're aware that the Institute Max Planck Institute in Munich in 2017 has established an initiative which is called Smart IP for Latin America. There is a website, you easily find the website if you Google the name of the initiative, and the aim of this initiative can be found there, so to speak, a mission statement, which basically is to provide an independent think tank that serves as a bridge between basic research, this is what we try to do as an institute, and public policy, in particular in Latin America. Brazil is one of the key countries of the initiative, or for the initiative, and is therefore particularly worth mentioning that one of the currently 3 observatories of the initiative exists here in Brazil, along with one in Argentina and one in Colombia. This in Brazil is based at the Universities of São Paulo and Curitiba, with the leading partners Juliana Krüger-Pela and Marcos Barcellos. One of the core topics we are focusing on in our initiative is what is often described today with the grand challenges. And we are of course particularly interested in what role Latin America can play in overcoming such challenges. If you Google the term global grand challenges, quite a few different terms come up. Some of them, however, appear regularly, and I guess the example on the slide here is quite representative. In our initiative, we are mostly interested in the ones circled in red on the slide, notable because addressing these grand challenges depends to a significant extent on the use of resources that are extensively available in Latin America. It is therefore apparent that Latin America can play a prominent role within these areas in particular. However, it is clear that precisely in these areas the most important thing is whether and when the still necessary and often groundbreaking innovations will happen. To overcome the global grand challenges, it is largely irrelevant where in the world such innovations happen, and it also doesn't matter who is the inventor, but it is crucial that the latest technologies can be used in places where they have the greatest impact. If Latin America in particular has unparalleled amounts of renewable resources, such as hydropower, sunshine and wind, for instance for the production of hydrogen, or capacities for food production, it also has to be possible to use the necessary technologies here in Latin America. In fact, if you're talking of the global grand challenges, we have to be aware that these only can be mastered if each global player plays the part they do best, and if everyone works together as well as possible. Now, when one speaks of technical innovation, one inevitably thinks of patent law. This is so because patent law is generally regarded as a mechanism for creating incentives for innovation. This may suggest considering how patent law could be modified in such a way that desirable innovations, for example, for particularly sustainable use of natural resources, are promoted, whereas bad inventions are discriminated by patent law in such a way that they no longer occur at all. If you look at recent publications on patent law, you will see that this has become a real fashionable topic. However, I would like to take a slightly different perspective here, and above all ask what role patent law really is able to play in connection with the global grand challenges. In fact, I believe we have to take a more differentiated view on patent law. One problem of patent law is that everything seems quite simple. An average political leader of which party ever would probably quickly agree with the statement that more protection through stronger patents leads to more innovation. This, however, is based on an incorrect or at least simplistic assumption. The belief that the mere possibility of being granted a patent and thus having kind of a market exclusivity creates an incentive for innovation per se. Why this assumption is simplistic is not very difficult to understand. The prerequisite for innovation is that someone is willing to invest in the first place. Investors mostly are private actors, and whether or not they are prepared to invest ultimately depends on what they expect to gain from their investment. Since a typical investor is a homo economicus, it is likely that he or she primarily strives for monetary benefits, in other words, for a worthwhile return on investment at the end of the day, profit. Consequently, the necessary investment incentives ultimately come from the market, not from IP rights. The mere possibility of obtaining a patent as such does not provide for an incentive. Without the prospect of reasonable profits, there are no investment incentives, and ultimately there is no innovation. This does not mean that patent law has no function. On the contrary, there are reasonable theories that can explain why patents may indeed be important. According to one of these theories, patents have the function of preventing so-called market failure. Market failure usually is understood as an inefficient distribution of goods and services in the free market. Under such circumstances, the probability increases that the market does not generate what is desirable and what could actually be generated. However, this theory of market failure should not be oversimplified either. When patents come into play, they may have quite different effects with regard to such market failure. A patent actually may fulfill its function, in particular it helps to prevent market failure, but it's also possible that patents have no effect at all. A patent does not good, but it does also not harm. It simply does not fulfill a function. We'll come back to that. Or, and this is particularly important, a patent not only does not fulfill its intended function, a patent may be the actual source of market failure. Let's look at that in more detail. However, allow me to make a caveat here. The concept of market failure is quite controversial in literature, especially in economic literature. I don't want to go into that here. I just want to clarify that we will use the term as broadly as possible, covering all kinds of mismatches as assumed social between an assumed social need and an actual supply. The point here is simply to show what role patent law can play in such a situation. After all, we just have explained, we can essentially distinguish three constellations which are related to the three different types of market failure, but in which patent law in fact plays very different roles. The first constellation is better illustrated by a classic example than by any abstract definition. Imagine the pharmaceutical industry lacks the incentive to develop drugs needed to treat so-called rare diseases or orphan diseases, so-called orphan drugs. The reason is that the number of potential consumers is simply too small to allow the necessary investments to be recovered. This kind of disincentive also plays a role when it comes to the global grant challenges. As long as consumers have the choice between cheaper but less sustainable and more sustainable but more expensive products, it cannot be assumed that there is a sufficiently high demand for sustainable products. Consequently, since investment incentives come from the market, no one will make an invention just for the purpose of getting a patent. This can be seen as a first type of market failure, but in this situation it makes no sense to turn at the screw of patent law in any way, for example by accelerating examination of patent applications or by lowering the fees. Rather, investment incentives outside of patent law have to be created to counter this first type of market failure. We will come back to that in a few minutes. The second type of market failure occurs when there is a demand for innovative products, but potential investors are still reluctant to invest. This is above all the case when they anticipate the risk of free riders. Here we find ourselves in the middle of one of the classic justification theories according to which patents are necessary to prevent market failure. In fact, the role of patent law is to provide potential investors with temporary legal market exclusivity and thus a certain degree of economic security. However, patents not only help to keep free riders out of the market, patents also have the potential to drive unwanted competitors out of the market. You probably all remember the discussion about so-called non-practicing entities, or to put it more populistically, patent trolls. If patents are used for such purposes, the intended function of patent law very quickly turns into its opposite, and this is particularly dangerous when it comes to innovation which is needed to meet the global grant challenges. First, third parties may be deterred from making investments that would lead to subsequent, maybe even better innovations, because they are afraid of being prosecuted by the holder of the underlying patent. As a result, the potential to meet the global grant challenges with advanced technical solutions may remain unused. Second, technologies that would contribute to overcoming the grant global challenges have been developed, but they are patented and therefore they are not generally available. This is the case if the patent holder is not prepared to grant licenses on acceptable terms. The reason for this is usually that the holder wants to achieve the highest possible return based on his or her exclusive right. When a patent is used in such a way, ultimately dysfunctional way, it is the patent law itself that leads to the third type of market failure by hindering that rather than encouraging innovation for its use. And the question arises, what the legal remedies are to avoid this. Let's look at that, but for all three types of market failure. If in the absence of market demand, there is no point in turning the screw of patent law, investment incentives can be stimulated to a certain extent by other, in particular government or state measures. This covers a broad field that no longer concerns patent law, but at least a cursory overview is worthwhile, focusing on two significant options. On the one hand, the state can positively decide which desirable inventions should be incentivized by providing advantages, typically on monetary nature, to companies that are potentially willing to make such investments. Amongst other measures, you have the ones listed here on the slide. I will not lose time by reading them in detail. On the other, sorry. I can go there.
Take your time.
Okay.
It's all yours.
Okay. So, you read if you want. So it's grants, subsidies, tenders, benefits like tax, and so on, or direct order of innovation and state innovation. On the other hand, the state may decide negatively which technology should not prevail on the market and should therefore disappear. This can be done through indirect attempts, such as emission certificates. However, the state can also intervene directly. In extreme cases, the state can even ban products that are based on certain undesired technologies. Such measures necessarily imply that the state decides directly or indirectly which technologies should or should not prevail on the market. This is not without risk, as it is more than questionable whether state actors, which mostly are government employees preparing decisions of governments or parliaments, have the necessary insights and information. It seems preferable for the state to simply set targets that allow market-driven selection processes of best solutions by private actors who are the frontline every day and can constantly and highly dynamically adapt to changing circumstances. In this respect, negative state decisions appear to be preferable to positive ones. This is because if the state positively determines which technology should prevail, it creates negative incentives to invest in alternative technologies. Even so, alternative technologies might be better in the long run. In contrast, negative state decisions promote technology competition, which means that the market forces still can exert a significant influence on which alternative ultimately prevails. Warning examples can be found on the automotive industry, where the European Union in particular is trying to force the market to increase the portion of battery-powered electric cars, completely disregarding not only the reality in other parts of the world, but also without any certainty that batteries will be the technology of the future. I guess we do not need to delve further into these regulatory options outside of patent law, as our question is precisely the role of patent law, and as we have seen, patent law indeed plays no role as long as the aim is to counteract market failure caused by a lack of market demand. Where market failure is at risk due to free riders, patent law obviously plays its key role. And it's certainly not wrong to say that it plays this role quite well for the most part. However, it is questionable whether the current patent law is up to the task when it comes to innovations that are needed to tackle the global trend challenges. Asking this question at all, however, is not self-evident, because the current patent law does not seem to differentiate between whether a technology is good, for instance sustainable, or bad, for instance accelerating climate change. In fact, the conditions for granting a patent are always the same, because patent law is, at least in principle, so-called technology neutral, which is also stipulated in the international legislation, Article 27 TRIPS. Changing this would lead to an actual paradigm shift, the consequences of which would have to be asserted very carefully. We cannot go into this in detail here, but we can at least briefly consider what regulatory options exist at all and what they would entail. In principle, despite of this provision, there are two options for increased differentiation in patent law. Either one discriminates against undesirable technologies, or one privileges the desired ones. In extreme cases, discrimination would mean that patents are no longer granted for undesirable, for instance, environmentally harmful technologies. Under current international law, essentially two approaches are conceivable. I try to make this short because it may be too technical, but it's nevertheless quite interesting. Section 2 of Article 27 allows member states to exclude certain innovations from patentability in order to protect order public, public order, or morality, mentioning in particular the protection of human, animal, and plant life or health, in order to avoid serious breaches to environment. At first glance, that sounds promising. As far as morality is concerned, however, the question arises as to whether technologies that no longer appear desirable today, for instance because they are not sustainable, but which have been common for decades and for which there are still no economically or technically convincing alternatives, can really be classified immoral. Public order, in contrast, usually is considered as a fundamental principle of the legal system. Nevertheless, it is questionable where the boundaries are to be drawn in detail, and above all, by whom. A classical patent examiner will not be able to decide on that. A second approach, basis on Section 3 of Article 27, this provision allows member states to exclude certain technologies per se from patent protection. The legalata, however, the TRIPS allows to exclude from patent, what TRIPS allows does not refer in any way to non-sustainable technologies, for instance. If this were to be done, the international legal basis would have to be adjusted, which is a long, thorny, and uncertain path. However, I have my doubts as to whether there is any point in pursuing such a path. After all, the mere fact that the product enjoys patent protection does not imply that it can be marketed at will. As we have seen, the state can also make negative technical decisions, technological decisions outside of patent law. The effect of this is likely to be much stronger. Once again, we have to remember that incentives do not come from the prospect of a patent, and disincentives do not necessarily come from the lack of a patent. Decisive is a sufficient market demand. It is therefore more effective to, so to speak, dry up a market by ensuring that undesirable products are no longer available than to refuse legal protection to such products. There is quite a nice example from Europe, but with a worldwide impact, which was the ban of the traditional hot light bulbs, without specifying concrete technological alternatives, but this ban has heavily stimulated the market for cold lights worldwide, the LED lamps today. Instead of discriminating undesirable technologies, desirable innovation can also be privileged. There are not many possibilities for this because patent protection, as we know, is already so-called absolute, which means that anyone who receives a patent can in principle prevent any authorized third party from using the protected technology anyway. Nevertheless, at least two options are conceivable. Either patent protection for desirable inventions is granted more quickly, earlier so to speak, or patent protection is granted more cheaply for desirable inventions than it is the case for ordinary inventions. The first option is often paraphrased with the term fast track. Criteria can be once here mentioned on the slide: patent classification, state accreditation, etc. In Brazil, such a procedure has actually been implemented, as you certainly all know. Likewise in Australia, Canada, China, Israel, Japan, South Korea, United Kingdom, and United States. However, there are hardly any robust studies to date on what the effects of such a fast-track procedure actually are. One of the projects of our initiative, Smart IP for Latin America, therefore precisely aims to find out more about this in Brazil. 4 advantages associated to the fast-track procedure can be considered. Maybe there are more, but we look at 4. However, the question is whether these advantages could not be achieved in another way as well. First, once the patent is granted, it allows to defend against free riders. There is, however, also the possibility of granting provisional legal protection to the patent application once it is published, which can take place quite quickly, much faster than any kind of fast track. The European Patent Convention provides for this opportunity, but is hardly used by its member states. Italy is one of the exceptions. The second argument relates to the transaction capacity. In fact, a further theory of patent law states that an exclusive right is necessary to make a technology marketable. This is certainly true, but not only patents can be subject of legal transactions, but also patent applications. This is also explicitly provided by the European Patent Convention in a chapter which is titled the European Patent Application as an object of property. Even the argument that the successfully completed examination procedure provides more legal certainty than a mere patent application is not entirely convincing. Granted patents can equally subsequently be annulled. The third argument is probably the most convincing one. As mentioned at the beginning, inventions require investments, and private capital plays a decisive role in this, but in particular private investments like banks obviously want legal certainty. However, even this is it okay? Can you hear me? Okay. Even this third argument is weakened by the fact that the patentability of an invention as such is no more than an indication that there is a market for the protected technology. In contrast, there is Okay. Again, there is no indication that there is a market for the protected technology. In contrast, if there is no market demand, a patent is of no use neither for the owner nor the inventor. Is it now okay?
Is it now okay? Tá bem para vocês agora para ouvir?
Okay. A fourth argument stems from economic studies. They examined how often patents are cited and found that this is more than twice as often the case with the fast-track patents than with technologically related patents that are examined in the traditional way. If citations are taken as a measure of knowledge spillover, this suggests that the fast-track procedure tends to promote the short-term dissemination of knowledge. Especially in relation to desirable inventions, this is certainly important. But here too, the question arises as to whether alternatives are conceivable, such as grace periods for certain pre-publications of particular types of inventions. You certainly realize that I'm rather critical, but don't take me wrong. Fast-track procedure can have certain advantages. Nevertheless, I think it's worth weighing up the costs and benefit of such fast-track procedures carefully. Above all, it is anything but clear for what reasons the fast-track procedure is actually used or not used by the patent applicants. Beyond that, it should be taken into account that expected positive effects might not materialize from the outset if each country goes its own way. Without the minimum of international coordination, the fast-track option is unlikely to be of much use to address the global grant challenges. Furthermore, it should not be underestimated that in a number of sectors, the granting of a patent protection is not sufficient to bring a product to market. Particularly when additional administrative steps are required, the question arises as to whether a regulatory fast track would not be more significant than one limited to patent law. As part of the initiative Smart IP for Latin America, we indeed also are planning to investigation into the possible regulatory fast track in Brazil. Alternatively, cost advantages could be considered for desirable inventions. In particular, patent or procedural fees could be reduced. Prima vista, this may make sense. Nevertheless, certain doubts are justified, but I will not go to this in detail, but in a nutshell only. First, in relation to the development cost of a technological innovation, the patent fees are comparatively marginal. If investments are crowned with success in the end, fees normally can be financed. And if they are not commercially successful, a patent will be dropped eventually anyway. Second, it would be anything but easy to establish criteria for who should benefit from lower patent fees, not only from a technical point of view, but also, for example, to ensure that global corporations are not subsidized when they do not need to be so. Third, startups that are really dependent on such benefits could probably be helped more efficiently and in a more targeted manner by supporting them with direct payments, as is the case, for instance, in Denmark. The third type of market failure, which is caused by dysfunctional uses of patents, deserves more attention than ever before. This applies in general, but especially where technologies are concerned that are ultimately needed to overcome the global grant challenges. Essentially, the issue here is that certain types of technology transfer that appear desirable for superior reasons do not take place. Either it is the case of a follow-on innovation that is hindered because a younger innovation has to make joint use of an older, still patent-protected innovation without permission from the patent holder of the older innovation. Such uses constitute patent infringement. Or it is about ensuring that existing technologies can be used at all. The example of sustainable energy production shows how important the second constellation is when one considers that the resources required for this, such as wind, sun and water, are often not available at places where the corresponding technologies for this use are being developed. In other words, it must be ensured that technologies that are required to overcome grand global challenges, despite existing patent rights, can be used at all and can be used in places where they can develop their potential most effectively. Against this background, the question arises as to which legal remedies in terms of regulatory mechanism are available to ensure such necessary technology transfers. Essentially, there are four categories of mechanism which we only briefly touch on here. Permission to use a patent technology can be granted directly by law in terms of statutory license if the right holder is not prepared to grant licenses on the basis of contractual situation. Also, international law expressively provides for this mechanism in Article 30, which is quoted here. It has to be implemented nationally. A number of countries do make use of these opportunities, but as far as can be seen, no country does so with special focus on particularly desirable inventions. That said, the benefit of the mechanism of a compulsory license should not be, of a statutory license, should not be overestimated, as two special features must be taken into account. First, the requirements set out in Article 30 are relatively narrow. Also, it is significant how this provision is interpreted. I would like to mention here a so-called patent declaration on the regulatory sovereignty that member states have under TRIPS. This declaration was developed by more than 20 international patent lawyers exactly 10 years ago. It was today, 10 years ago, that it was published. This patent declaration shows how flexible this norm could be used. What deserves special attention in this context is the passage that legitimate interest of third parties must be taken into account. This is the green part of the provision. This could be seen as a gateway to using the mechanism of statutory license more extensively than has been done today. Second, however, statutory licenses are of a general abstract nature. They therefore do not allow for a case-by-case assessment. However, this is precisely the point when it comes to the determination whether an enforcement of a patent in a specific situation leads to dysfunctional effects that are contrary to public interest. One alternative are compulsory licenses, which are characterized by the fact that the permission for use is not directly granted by law, as in the case of statutory licenses, but by a state authority, usually a court, which in fact takes into account the specific circumstances of an individual case. Compulsory licensing is also provided for in international law, Article 31, and the member states have a relatively wide scope when it comes to determining the grounds. This is also shown in this patent declaration. This compulsory license mechanism has gained considerable popularity in the context of the COVID pandemic. You might have heard of that in relation to the production of vaccines. However, it is obvious that compulsory licenses could also play an important role in connection with the technologies that are needed to overcome the grand global challenges. However, the question is whether the requirements of international law, de lege lata, are adequate for this. If the aim is not to hinder subsequent inventions or innovation, international law does recognize a special permission. This is the compulsory license for dependent invention, or so-called follow-on invention, Article 31, letter L. But it is subject to two conditions that are probably too narrow for two reasons. Number one requires that the invention claimed in the second patent shall involve an important technical advance of considerable economic significance in relation to an invention claimed in the first patent. It would be worthwhile investigating whether, for example, a considerable ecological significance of a subsequent innovation should not also be sufficient reason to grant a compulsory license. Secondly, this compulsory license obviously presupposes that the latter innovation itself is patented, because number two requests the possibility of a cross-license to the benefit of the older patent. Obtaining a patent for the subsequent invention may be in the interest of the inventor or the investor, but not in the interest of the general public. On the contrary, the general public benefits most when an invention can be freely used, including to further develop the technology behind it. Ergo, it makes no sense that the inventor is not entitled to the grant of compulsory license simply because he or she waives legal protection for their own follow innovation. If, on the other hand, it is a matter of being able to use an existing technology at all without developing it further, there is currently no basis in the national law for enforcing such a possible use. From a patent law perspective, however, this is also difficult to imagine if such use is made on a commercial scale based on a compulsory license. Ordering compulsory license measures for this would undermine the core of patent law, as its purpose is precisely to allow but also to prohibit commercial exploitation of the invention. The legal doctrine, in contrast, recognizes at least one situation that is not mentioned in international law, but which actually involves use on a commercial scale, the so-called local working requirement. Pursuant to this, a compulsory license can be granted in a country in which the patent holder does not make sufficient use of the invention without being able to justify this failure. However, the rule relates to this directly supports of supply of a domestic market, typically an emergency, for instance, supply of urgently needed medicine. Alternatively, the member states are free to issue compulsory license for the public interest, according to accepted doctrine. From a historical perspective, however, this is also about temporary emergency. This does, of course, not exclude from the outset the possibility of interpreting and applying the compulsory license in public interest in a new, broader way. But even then, the question arises as to whether it is enough for each country to consider for itself which specific regulations are required to ensure that the technology can be used domestically if it is needed to tackle global grand challenges. Ultimately, such mechanism could only have a noticeable effect if the international community were prepared to coordinate the necessary steps and take them together at the level of international law. The third mechanism is of a procedural nature. It is about how unconditionally patents can be enforced, or controversially, whether there are grounds to refuse to do so. Essentially, this is about the so-called denial of injunctive relief, which has been developed in case law, ultimately on the basis of equity and a much more flexible common law system, above all in the United States. I won't go to this here in detail, but I think it would be worth having a policy discussion, especially in Latin America, about how much flexibility is necessary to protect national economic interests. Fourth mechanism is patent pools, which are typically... Okay. Yes, indeed. Wonderful. So don't have to eat it. Fourth mechanism is patent pools, which are typically based on agreements between two or more patent holders with the aim of licensing their patents to each other or to third parties. The positive effect is obvious. Access to innovation in the pool is made easier. However, the weakness is also obvious, and as long as a patent pool is voluntary, there is little incentive to include not only patents with low prospective commercial success, but also the most promising technologies. Especially when it comes to particularly important technologies whose widespread use is in the public interest, as is naturally the case with technologies that may help addressing global grand challenges. The idea of making patent pools mandatory suggests itself. However, mandatory patent pools would encroach extremely far into private autonomy of the right holders, which is why the consequences would have to be examined very carefully in advance. Because in fact, even in the field of technologies of particular general interest, patent protection is and remains an essential instrument for providing some certainty to investors that a risky venture may pay off in the end. In other words, the prevention of the third type of market failure, as important as it is, may not be taken so far that it ends up in triggering the second type of market failure through free riders. So, what are the findings? Those who expect patent law to have a decisive role in overcoming the global grand challenges are likely to be disappointed in light of this analysis. Also, patent law does not play no role. Its effect and possibilities should not be overestimated. Patent law certainly helps to counteract the second type of market failure that threatens if free riders cannot be fended off, but this applies in general, regardless of technology. However, we should really primarily be concerned about the first and the third type of market failure. As we have seen, when market forces in terms of market demand are not at play, regulatory measures outside of patent law are required to promote innovations needed to tackle the global trend challenges. This is indeed a complex undertaking because the path from market failure to state failure is very short. If technological decisions by the state are misguided for political or other reasons, society as a whole pays the bill, and the bill extremely high. But as I said, this is a broad field and not really our topic. On the other hand, it is one of the key challenges if patents are not the solution to prevent market failure, but the actual problem, the source of market failure. The fact that patents can also have dysfunctional effects has long been discussed in science, but so far this had little impact on legislation and in legal practice. In this respect, the grand global challenges should now really be used as a wake-up call. One does not have to be generally critical of patent law to realize that it has the potential to have dysfunctional effects under certain circumstances. This must be taken very seriously, especially in relation to the global trend challenges. It would be fatal if patents of all things were to hinder technology transfer that is crucial to overcoming such challenges. However, the mechanisms currently in place are hardly sufficient to prevent this. But it is also not enough for individual national legislatures to think about it on their own. An international coordinated action is unavoidable, and I think the signs for this have rarely been as favorable as they are at the moment, perhaps thanks to the COVID pandemic. Brazil is a key country to overcome the global trend challenges in every respect. On the one hand, through its own innovative strengths, and on the other hand, through its unique availability of national resources. In particular, in this country, it seems to me be extremely worthwhile exploring further on this legally, but also in particular economically. We will try to contribute with our initiative Smart IP for Latin America, but I also very much hope that Brazil itself will play an important role in close cooperation with other Latin American countries, of course, but also with our other global players who are crucial to tackling the grand global challenges. Thank you very much.